Good afternoon, everyone. Thank you for those of us joining us today, and good morning to those on the West Coast. Thank you for meeting with us to discuss what we think is a pretty groundbreaking executive order. That's Executive Order 13950, Combating Race and Sex Stereotyping, and how it might affect your organization. Real quick before we get started, please remain alert throughout this presentation, because later in the presentation we'll share a CLE code that you can use to get your CLE credits. Also, in a couple days, we'll be circulating an email with today's slides and a link to a YouTube recording if you want to listen to our voices again. My name is Dismas, or Diz Locaria, and I'm a partner in Venable's government contracts practice. A great deal of my practice is spent advising federal contractors and grant recipients of all sorts of federal compliance requirements, which is why we've been tracking this executive order so closely. But before we begin today, let me allow my colleague, Krista, to introduce herself as well.
Hi, everyone. Thank you again for joining. We're really excited to be able to host a webinar on this. My name is Krista Nunez, like Diz said, and I'm an associate in Venable's DC office in the government contracts group. I do some of the same work as Diz, but I also love to litigate before the GAO and the Court of Federal Claims. So we will just get started in a moment, and we're really excited that all of you could attend today.
Thanks, Krista. Okay, well, we have a packed hour for you today on this executive order. So obviously we want to give a little bit of an overview of the order itself, walk through some of the details of that executive order. We're going to talk about its impact on grant recipients, recognizing that not everybody here necessarily is a contractor. We'll talk about the definitions, some possible exemptions that may be on the horizon. We want to talk about this hotline that you may or may not have heard of, which is already open. Talk about compliance issues and enforcement issues, and then kind of what now and what next. Certainly, we may have time at the end for questions, but encourage you to feel free to shoot us questions throughout the presentation, and we're happy to try to address those as we get. Okay, so before we get into the nitty-gritty, let me give you a little bit of background on the EO itself, just to frame things up. So as most everybody on this webinar probably is aware, which is why you've logged in. On September 22nd, President Trump issued this executive order for the purpose of instituting really what is a federal ban on the use of workplace training that inculcates in its employees or promotes the concepts of any form of race or sex stereotyping, of any form of race or sex scapegoating, excuse me. The requirements set out in the EO apply to both federal contractors, subcontractors, and as we'll talk a little bit later about, there's going to be requirements for grant recipients, but we don't quite know yet how that's going to be impacted. So with that, let's discuss some of the finer details of the executive order. And I'm going to first start with key dates, and then we'll dive into definitions. We'll talk about the mandatory contract provisions and flowdown. We'll talk about effects on prime-sub relationships, the savings clause, and some of the notice obligations. So with respect to key dates, as I already mentioned, September 22nd, the executive order was issued. Just a couple days after, right, September 28th, they opened the hotline, okay? So that hotline is already open and accepting information, and we'll talk more about the hotline in a little bit. As you may or may not know, this morning, the request for information was released, and we plan to talk about that, although it was released at a point where we couldn't add detail into our slides, but we definitely will be talking about that later during this presentation. And then, as most of you are probably tracking, November 21 is really the next big date related to the executive order, as there's two things that are happening. One, we should be hearing, well, we won't be hearing, but agency heads are supposed to be reporting in on how they want to implement this from a grant perspective. And the effective date is on November 21. So even though a lot of activities already occurred, it actually isn't fully effective until November 21. I think that does create some potential ambiguities and some questions about things, and we're gonna explore some of those issues today. One item, obviously not on this timeline, but I think relevant to this executive order is obviously November 3rd. We have an election, and that may help give us some clarity as to perhaps the longevity of this executive order, and we'll speak about that a little bit later in today's presentation as well. So with that, I want to go ahead and turn it over to Krista to talk about some of the definitions. Krista.
So as some of you might have had the chance to read these definitions from the get-go, I'll just say these are pretty broad. And even as an attorney reading these, you have to take a step back and say, what do some of these things mean? Especially since these are so critical to understanding the rest of the executive order. Hopefully there's going to be some additional guidance from DOL that better explains what some of these are, but I think one of the easiest ways to understand what these definitions mean and how they work in practice is to sort of contextualize the definitions into recent events. So in light of things like the protests and other things that we discussed about in the 2 articles that we've put out, divisive concepts is basically saying, one group of person or one gender is doing this or that, and it's racist or it's sexist or it's oppressive. And one of the things that we had picked up on initially when we got this, when we read the executive order, and then of course have had the opportunity to see what Scalia has said, see what OFCCP has said. And one of the confirmations, as you'll see on the FAQ page, is that implicit and unconscious bias is one thing that this executive order seems to be particularly concerned with. And so that 3rd paragraph there is one of the things that we recommend that you pay a lot of attention to. And quite frankly, you should just probably avoid any implicit or unconscious bias training, just particularly because these definitions are so broad. So try to stay away from anything that could arguably be decisive concepts during discussions or during actual training materials. Some of the other key definitions are race or sex stereotyping. That's kind of what I talked about, and we'll hit on this a little bit more, but the RFI that got released this morning actually sheds a little bit more light and perspective on where exactly they're coming from when it comes to race or sex stereotyping. And then same with race or sex scapegoating, just, avoid fault, blame, bias to a particular race or sex or to members of a class. It's kind of confusing to, incorporate these definitions in real life when, of course, there are affirmative action goals that many companies have, and they're trying to promote, especially in light of these recent events. But staying away from categorizing individuals based on gender or race is the best way to avoid race or sex scapegoating or stereotyping, because the purpose of this is obviously to avoid inculcating in your employees or, adamantly instilling in them, teaching in them that they have to, believe these same things as you or not, can be kind of a tricky area. And so one of the key parts of the executive order that we wanted to really highlight is this mandatory contract provision and flowdown requirement. It is a little bit unusual for a president to include in an executive order the exact language of a contract provision. As some of you may know, it's a little bit more normal that that the president would direct the FAR Council to go through the formal rulemaking process. And so the fact that this executive order actually included that from the get-go, when looking at some of the dates, including when it becomes effective, November 1st, it's kind of interesting because the government clearly here, the administration wants people to be fully aware that this is going to be incorporated in all of your contracts. And so one of the unique aspects of this that we've kind of paid a lot of attention to is that, you could have contracts now and maybe you're not going to have a contract that you're interested in bidding on, for example, until January of next year. Well, if the Trump administration is still here then, this goes into effect November 21st. If you get a single contract after that date, it affects every other contract that you have. If you get a single subcontract that's a government contract, it affects every other contract that you have, because as the regulations stand, which there are none, and the FAQ page doesn't really provide that much information, pretty much you have 1% of your work that has this contract provision, it applies to everything else. So we're really hoping there's exemptions, and we'll hit on that a little bit more. But as of right now, this clause is going to be included in every single contract. And, you know, based on some Federal Circuit precedent, it's unclear if even if this contract provision was accidentally not included in your contract, that it could possibly be read in based on the KCON decision. Out of an abundance of caution, I would just assume it applies to everything. And so we really recommend that contractors and subcontractors, the second that November 21st date hits, to really be aware if you get a follow-on purchase order or a new subcontract or a new contract after that November 21st date, because it affects the rest of them, even if it's not in those contracts, because it's looked at as a company as opposed to just the particular contract. And then as you can see in the second paragraph here, everything does have to be flowed down. We are hoping that there will be some exemptions on the flow down levels at the different tiers, or for example, you know, commercial item contracting. But for now, the entire clause has to be flowed down to every single contract, from the prime contractor to every single subcontractor and every single purchase order. So that is something to be mindful of, and really be alert as to when your organization receives a new subcontract, contract, or purchase order after that November 21st date.
So Krista, let me go back to that other slide real quick. A question came through on workplace training. What constitutes workplace training? And that's a great question. It's not one that's defined in the executive order itself. So it certainly does lend itself to maybe some reasonable interpretation. But I do think that the regulation, or at least the executive order, the FAQs, and the more recent RFI, which we'll talk about, gives an indication that mandatory training is absolutely going to be, you know, considered workplace training. Voluntary type training, I think that might be a way to try to get around this executive order. But, you know, I would expect under the current administration and enforcement that even voluntary training could be questionable. And I think that's one of the things that's so difficult about this executive order, is that there are things that are just plainly ambiguous. And, you know, it's clear there's an agenda here, right? Based upon recent events in our country, based upon recent trainings that we have heard of in certain states, and also, you know, that workplaces have taken on. And I think that runs counter to this administration's view on these sorts of issues. And so I think the challenge is this, is that, and we're going to talk about all these different issues, but the challenge is this, is that if you have a single worker who is uncomfortable, there's a hotline now that is going to allow that employee to raise that concern directly to the federal government, a direct path, right, to investigators. It's unclear, you know, what the resources are going to be of that department of OFCCP to investigate. It's unclear, you know, how aggressive they're going to be with their investigations. And some of this has come out in the RFI, and we'll talk about that. But it does create risk for diversity D&I type trainings. One of the things we've talked to a number of clients in the past couple weeks about the legality, which we'll talk a little bit about that later, but also how to conform with this. And it does create a lot of problems. You know, one of the issues that I'm a big advocate. I do a lot of ethics and compliance training for clients, and I'm a big advocate for in-person discussion type training. But this executive order makes it really difficult for D&I, because you don't know where those discussions are going to go. And even though you may have a completely compliant plan, because of where a discussion goes, it could take you down kind of this path. And I think that's things that we are currently just advising clients to be mindful of. One other quick point, Krista, I'm sorry, and I'll let you jump, is that some of the research that we've done, and by I mean we, Krista, is that while it's very unusual for the president to write contractual language in executive order, We're not 100% certain that it is something that is not within his authority. It does look that there's case law. It doesn't happen often, but it does look like the president has the authority to do what he's done with this executive order. That's not to say there might be some ways to challenge that, but a lot of people have asked us, well, how come it hasn't gone through the FAR Council? What about the rulemaking? All of that. There is authority granted to the president to take this type of action, or at least some basis of support for his action here. So I'll pause there, Kristen. I'll let you get us back on track.
And I'll just add one other thing to that really quickly, is that I don't think it's a coincidence that the administration intentionally modeled some of the exact language of this executive order off of the Equal Employment Opportunity Clause that you'll see in many contracts. That clause has withstood judicial scrutiny in a lot of different ways. And so I think this was deliberately done in order to sort of solidify and enforce the way that they've structured this so that it has more judicial defenses if it is challenged on, for example, First Amendment grounds. And then just to kind of summarily hopefully hit on a couple people's questions before I move on from this contract provision slide. Basically, we'll hit on this a little bit with respect to some of the exemptions, and Scalia himself has talked about different ways in which people are allowed to have discussions. Frankly, the way that I view it, if it was my company, I would just completely avoid altogether any discussions that arguably categorize one race or gender in a particular group. Just stay away from it. Even if it's not a formal training, because like Diz said, you can have anyone in your company calling this hotline, and we'll get more into it when we hit on the RFI because they did get into more of the specifics, but all it takes is one employee being upset, calling the line, and then your company could be under investigation. It's no joke, and the way that this was written, I think it was intentionally broad. They're trying to leave loopholes to have arguably more authority to investigate different things. So whether it's, a lunch, like a brown bag lunch that you're having, or some sort of other informal training, because training is not defined in the executive order, we don't know the exact parameters of what the government would construe that to mean. And so until there's more guidance on that, it's kind of hard to say one way or another what's safe or not. And then when it comes to implicit and unconscious bias, just don't do it. Just don't talk about it at all, because we'll talk about some of the reasons for that as we keep going. But my attitude on this is sort of better play it safe than sorry. And they've come out and said, discussions are fine. And as you can see in our most recent article, statements that they've made during other conferences kind of undermine the fact that you are supposedly allowed to have these discussions. So just avoid those topics altogether, at least until we have more guidance from the Department of Labor, which they have indicated should be forthcoming. So I will move to the next slide. And one of the reasons...
Krista, hang on, because we're getting lots of questions, which is great. And let me try to just address a couple real quick. Number one, someone asked a question about the effective date, and that is correct. If you have a contract awarded prior to November 22nd, they should not include anything to do with the executive order. And the way it's written, it sounds like it's only going to be added to new contracts issued on November 22nd. In other words, it doesn't sound like, I'm not going to hold my breath, but it doesn't sound like it will be added to existing contracts. So if you have a prime or a sub awarded prior to November 22nd, it should not include this. It should not be amended to include this. But as soon as you get a single contract on November 22nd, it will apply across your organization, right? This is going to apply globally to your organization. So you're in for a penny, you're in for a pound. On the flow down, someone asked, do you have to flow down to all of your subcontractors? No, you would flow it down to your federal subcontractors on the contract that this is actually included in. So I just wanted to address a couple of those questions. Go ahead, Krista.
And again, we're really hoping that there will be more guidance that comes out on this. I'm trying to still review some of these questions. like Diz said,
No, let's go into
federal.
some of these. I think we'll address as we go on in the enforcement section or in the grant section. So let's talk, because this effect on prime sub relationship is going to be a significant aspect here. I want to make sure we cover.
Yeah. So basically, the effect on the prime sub relationship here is that, as we know, there's this mandatory flow down to your federal subcontractors. So the contractor, obviously has a certain amount of responsibility. They're in privity of contract with the federal government. So this executive order effectively imposes on the prime contractor an additional level of responsibility to almost serve as a quasi-watchdog for them to ensure that their subcontractors are in fact complying with the flow down provision. And so if the contractor for some reason, or say someone calls the hotline, an employee of the subcontractor, DOL gets a tip, oh, by the way, like this sub might be doing something wrong. They had this training on this and I think it's so inappropriate. Department of Labor says, okay, we're actually curious to see what this is. Let's take a little look at it. The Secretary of Labor is able to go to the contractor and say, hey, actually, I need you to go in and figure out what's going on here. We think there's something going on. They're going to start their investigation, but contractor, we actually want you to help us look into the subcontractor. And in fact, not only are you going to help, but you're going to help us enforce these provisions, including sanctions. And I tried to think of an analogous example that some people, well, hopefully they're not familiar with this legally, is when you have a False Claims Act investigation, for example, you'll have that whistleblower who kind of like works alongside. I think it's a little bit like that in that the prime contractor is working alongside DOL and enforcing. And if, the contractor really thinks that there's something wrong going on with the training with their sub, the contractor has an obligation, it seems, to tell the Department of Labor, and they can in fact request that the United States enter into the litigation to protect the interests of the United States. So if the prime and the sub have a dispute about the sub's compliance with the contract provision, the prime can go and say, hey, government, I need you to step in and you're going to help me take this action because, say, for example, the prime contractor needs to terminate because the sub says, I don't care, I'm not doing that, I'm not complying. Well, it puts the prime contractor in a predicament because what are they supposed to do? They have obligations under their contract with the government. They need to meet those. And so that's probably the thinking of the executive order, is to try to help the prime contractor if they get into this predicament, what are they supposed to do? But it is pretty interesting that essentially the government is asking prime contractors to sort of work alongside them and to help them enforce sanctions for noncompliance.
And I'll just note that is a significant step for the federal government to take, is to use its enforcement powers to not only require you to flow down, but actually to expect you to assist them in their investigative practices. That is a big reach. So just wanted to emphasize that point. Go ahead.
All right. So this might help to answer some of the questions that kind of just came in. So there is a savings clause, which Scalia recently coined these two paragraphs as under Section 10 of the executive order during a recent labor webinar. Basically, on October 7th, the Department of Labor, through the OFCCP, they put up their FAQ page and they decided to call these a savings clause, arguably to kind of protect against First Amendment violations. And so essentially what that means is they're trying to do a catch-all that says, even if the rest of this might not be totally clear on what you are or are not allowed to do, because government contractors do have First Amendment rights. And like Diz said, we'll get into that a little bit more, but they don't have the same exact rights as you would as a private individual from a legal standpoint. But you do have the right to make statements, to say other things, to discuss things, including on these topics, right? And that's the other thing, is that, you're not treated as a federal employee, but you're not treated as a private citizen. So you're somewhere sort of in between. And so these two sections basically serve to save the contractors by way of saying, hey, you're allowed to have discussions on these topics. Like, there's nothing that says that you're not allowed to do that. you just can't have training, it implies. It doesn't clearly state that. And again, we don't know exactly what the definition of training is, but basically they're trying to say, you know, you're still allowed to have discussions on these things. Just make sure that you don't violate anything else in this executive order. And so, you know, when Diz and I have talked about this, it's like, well, how do you reconcile not having training and avoiding any possible discussion on this? Because, you know, if you're someone in management of your company, like, you probably don't even want to hear any of these discussions going on, period, out of fear for the lack of guidance of what might happen in case, you know, someone calls the hotline or someone submits information in response to the RFI. And so they put this discussion savings clause in to basically say, no, like, you're still allowed to talk about it. We're not saying that at all. We're not limiting your speech at all. And so you are allowed to talk about it. But again, as we kind of mentioned, without any additional guidance on the parameters of this, and because the FAQ page and, you know, SCLEA has come out and said basically, there's no talk really about implicit or unconscious bias training. Like, that's a no. And so just, it's probably better safe to just stay away from this. And so these are arguably the government's defense against a First Amendment violation argument that someone could bring in a lawsuit. Personally, I think it's a little bit difficult to reconcile how these work in practice versus on paper. And so while you could argue these as a defense, no, it was just a discussion, that's kind of why we think it's better to just not discuss it, because if you have these organic discussions like through a brown bag lunch, the next thing you know, you could have one employee getting into a fight with another employee where they said, my employer held a brown bag lunch and this got brought up during the discussion. And who knows, maybe the person recorded it. They're allowed to send a recording of that conversation in. And then the next thing you know, you have an investigation that you're dealing with, all because you had a brown bag lunch generally on, you know, some section of a diversity training that turned into one employee saying something that violated the executive order. Like, we don't know. Maybe you're fine, maybe you're not. We don't have guidance. Arguably, you're allowed to have a discussion under the savings clause, but without additional guidance on sort of how that works. That's why Diz and I think it's probably better to just stay away from non-tailored discussions on, you know, equality and race and gender. If you're going to have discussions at all, it's probably safer to just really keep it structured to very defined points in accordance with, you know, the Equal Employment Opportunity Clause and affirmative action, and kind of see what's been allowed in that sphere, especially because this executive order is so closely modeled off of the Equal Employment Opportunity Clause. Did you want to add anything to that, or?
No, go ahead. Thank you.
All right, so one other thing is that not only do federal contractors have to flow this down to their subcontractors, they also have an obligation to provide notice to labor unions or representative of workers with which the contractor has a collective bargaining agreement or other contractor understanding. So the notice is supposed to be provided by the agency contracting officer. This isn't that different than the other types of notices that contractors would post. Basically, the administration wants everyone to be fully aware and have it out in the open. Everyone's complying. Everyone understands. There's never been a misunderstanding that this is now a requirement. So they've been really pushing the publicity and like the slowing it down the chain on every public-facing thing possible. And basically what this notice is it's affirming the prime contractor's understanding and agreement with the substance of the clause that's in the executive order. And so one of the interesting facets of this is that contractors have to post a notice of this in conspicuous places available to employees and applicants for employment. And so when we had looked at that, we're like, well, what does that mean, applicants for employment? Does that require you to have it in your job postings? Like, a lot of people often include, you know, an equal employment opportunity clause in their job postings. Does that require you to put it on your website? And we'll talk about a couple of the reasons that we're focused on companies' websites towards the end. But, you know, it seems that the administration's goal here is really to just have this broadcasted loud and clear all over the place. And so once this does go into effect, it is important to make sure that any notice in the posting of it does comply with the executive order. And if you're not sure about it on a new contract, it would certainly be a good idea to reach out to the agency contracting officer and say, hey, do you guys have any specific requirements, especially if there is no guidance from DOL between now and November 21st.
Thank you, Krista.
So
let me talk a little bit.
Yeah,
thank you. So let me talk a little bit about grants because I know that there's been some questions about that. First of all, when we talk about grants, we're always encompassing cooperative agreements with that as well. So the impact on grants is the same as the impact on cooperative agreements. They're covered by the same regulatory scheme. As I mentioned earlier on the key dates, so the way the executive order, different than contracts, grants, the executive order has asked agency heads to provide within 60 days of the order, so that's November 21, a review, that they review and identify the programs within their agency that they think they can make it as a condition of receiving a grant that they require they certify to not performing training of this sort. In other words, the heads of the agencies are going to come back to OMB and the White House and say, we believe these programs should be subject to this executive order, and potentially these ones should not be. Okay, that obviously creates a lot of uncertainty in the grant community. We also don't know what the certification is going to look like, although I would expect it to look very similar to the certification that's being pushed onto contractors. So assume for sake of the certification would be very similar to what contractors are going to take on, but whether it's applicable to your program or not is a big, kind of black hole right now. Now, based on my experience, I'm going to guess that programs that are predominantly performed overseas would not be subject to this, because it just doesn't really have any place in, when your workforce is predominantly non-American, right? But don't quote me on that. We have to wait and see how it shakes out. It's not clear when that's actually, so these reports are due November 21, but it is completely unclear when any certifications may actually be issued. So on the grant side, there's a lot of just big question marks, unfortunately. I think on the contract side, there's still some question marks, but we do know the effective date is November 21. So just stay tuned, and we'll try to keep folks updated on this as things move along. We'll certainly be keeping tabs on how this executive order evolves to impact the grant community. Krista?
All right. So as we've kind of talked about before, there are really, broad definitions. We've kind of discussed some of this. What types of training do these definitions include? Well, for sure they include diversity training. We know that. And another interesting aspect of this is, of course, if a contractor or subcontractor is providing diversity training to the government for their employees, for example, that is certainly included. So not only is it a company's internal training, but if your company offers training as a service, that definitely falls into this executive order. One thing that's, to answer someone's question, is that if you have a proposal submission due by 5 days before this executive order goes into effect, well, one thing that actually is pretty clear in this executive order is that it says in Section 4 that all government contracting agencies shall include in every government contract hereafter entered into the following provisions. So that means once that contract is entered into, so even if you submitted your proposal before the November 21st date, if your contract is entered into after that date, you're bound. And so the agency should be mindful enough to include that in your contract. We know that that doesn't happen all the time. It's pretty regular where there'll be a missing provision that should have been in your contract. Just expect it to be there if your contract was executed after that date. And then in terms of, the types of training that we have thought of is, implicit and unconscious bias training. In response to some of the recent events, some of the protests, we're here in DC, we saw many, many, many of them. A lot of companies tended to want to really address that head on, whether it was by formal statements or otherwise. I would be very careful with any public statement that you make right now because these definitions are so broad. And it's really tricky because the way in which the Department of Labor and OFCCP are kind of interpreting this executive order is what I keep harping back to, is that this is so inherently tied into the equal employment opportunity provisions and the executive order on those, which has been amended several times. And so even if they're arguably not able to get you under this executive order, they're already going after people who are violating, arguably, in their opinion, the other executive order. And so if a definition is not included here, but it's included there, the way that they've paired these together essentially allows them to kind of read the two together. And so I don't think it would be unfair to say, if you're not sure about something, look at what that other executive order says until we do get more guidance, especially since they are investigating them sort of in tandem. But unfortunately, because we don't know, for example, the type of training, if you're holding just any diversity training or, you know, announcing certain like goals for categories of a certain race or gender, like think twice about doing that, and you should probably talk to an attorney before doing it, just because these definitions are really broad. And the promotion and discussion provisions, like, you know, just be really careful, because the second, even though, you know, discussions are supposedly with that savings clause totally permitted, as we've said a few times, just probably don't until guidance comes out, because even though it's not effective yet, they're already collecting information. The hotline's open, and now the request for information is open, and so just be kind of mindful of that. And if you're not sure and it's not in the definition, but you think it might be able to fit into a definition, just assume that it falls under the executive order and probably cut it from whatever you were working on.
One thing I want to add, Krista, and I think there was a question on it, but also I think you touched on it, and I just want to underscore it, is that, you know, as Krista pointed out, this executive order runs very close to the executive order on equal employment opportunity. As part of that, though, you know, comes affirmative action obligations. And affirmative action obligations, right, require organizations to track how they're doing with respect to diversity and expect them to take efforts to improve diversity. And so what I want to point out is, I mean, there's obviously an inherent conflict there. But an area, it's one thing, you know, as we talk about workplace training, we talk about it, at least I think most people think of it in the broad sense, talking about D&I initiatives broadly. But think also about how you train your HR team, because your HR team may be the ones responsible for going out and making sure that you get a diverse pool of candidates in order to meet your affirmative action obligations. As of today, this executive order, you know, is on the books, and it's going to be effective on November 21. There may be challenges to it on these types of conflicts, right? The conflict between affirmative action and this, or as one of the questions pointed out, the conflict between this and maybe small business subcontracting, diversity in subcontracting. But the discussions your organization has internally about hiring a diverse workplace, hiring a diverse subcontracting workforce, don't forget that those discussions would also fall under these definitions of potentially workforce training. It's not just the broad D&I activities that your organization might take, but it's also departmentally, you may touch on issues that fall into these broad definitions. So I just want to make sure that people are looking at this holistically.
And one other thing I'll add to that is just for perspective, if it gives you context, the Trump administration has come out and instructed federal agencies to suspend all diversity training programs until they're deemed compliant. So, I mean, if that's coming from the administration, I think I would take a cue from that and, you know, really take a look at yours, because if they're suspending all diversity training programs, that means that whatever the government's been doing has probably not been in compliance with this executive order. So I just wanted to add that.
Okay, so next, possible exemptions. So I kind of alluded to this, and Krista's alluded to this as well. And, you know, somewhat usual for the president to write the contract provisions into his executive order, but that's what's been done. but also written into that executive order is that the Secretary of Labor, and that's Secretary Scalia, the son of the late Supreme Court Justice Scalia, he has the authority to potentially exempt categories of contractors or grant recipients from the application of this executive order. And again, if the past is a prologue, here are some of the things that we think could be exemptions, but as of right now, obviously, we don't know for certain. So the first is, and I kind of touched on this in the grant context, which is most of the employment obligations that the federal government puts on government contractors are only if the workforce is in the U.S. Because obviously, overseas, they have all kinds of different employment laws. And so one of the obvious places would be that this type of training would not apply to contracts that are for work overseas. So that is an obvious place. Like the EEO and the affirmative action requirements don't flow down, or they're not required for your workforce overseas. A lot of the employment pay requirements, Service Contract Act, those types of things, they don't apply to a foreign workforce, okay? So it would make sense that this employment executive order would also not apply to a foreign workforce. That's an obvious area. Another very obvious area is that the federal government all the time tells clients or tells contractors what is and what is not allowable, right? In other words, the government, contractors or grant recipients, are very familiar with allowability and unallowability. Contractors who deal with firm fixed price, maybe not as much, but certainly cost reimbursable contractors are, and they categorize those costs. An allowable bucket, allowable bucket. That would be another area that would be, I think, more in line with how government contracting and the government's imposition of certain social things upon government contractors and grant recipients would be better handled, would be that the government won't pay for this type of training. Generally speaking, you should, this training is protected, or this type of speech is typically protected under the First Amendment. It's just that the government doesn't have to pay for it. And so that might be an area that they carve out. And they say, if you can segregate the cost, then, we won't apply, this training doesn't apply. We're just not going to pay for this training. And then the other is, there's a whole swath of companies that are just commercial companies that happen to sell to the government. Does that now mean that these commercial contractors are completely subject to this thing for, maybe they do 1% of their business for the federal government, but now the other 99% of their business is caught up in this? That actually could chill the environment for contractors, right? Commercial companies may say, you know what, not going to do business with the federal government because I believe strongly in this. So that's an area that we also could see as falling within these exemptions. As of right now, there's no exemptions that we're aware of. Secretary of Labor has not issued those, but certainly something to keep an eye on. We'll certainly keep an eye on it as we go forward. Krista?
All right. And so significantly, the hotline is open, and that opened up on September 28th. Essentially what it is, there's an entire webpage dedicated to it. They have a phone number that you can call. Otherwise, you can just send an email. What's interesting about that is, of course, your employees, if they have access to it, can send in any training materials that you use. And so those will, of course, be the subject of, any DOL investigation into something. The OFDCP is the entity, which is part of the Department of Labor, that oversees the hotline. Basically, the hotline can create a triggering event where it's our impression, even though this isn't effective right now, because they issued this RFI today and because they issued the hotline so early, I don't think it's unfair to assume that the government is essentially compiling a ton of data right now, whatever they're receiving, whatever people will get. And in fact, they've come out and said, that the director of OFCCP, that they fully expect to get a ton of information from employees. The public's allowed to send stuff. You're allowed to send stuff yourself if you're one of the executives. But these calls are exactly what can instigate an investigation. So the hotline is already open. I would be mindful of that. And people can send in different materials on their email address, and they're going to take a look at that. We expect, I I don't think it's out of the realm of possibility that when that November 21st date hits, they're going to essentially have a hot list of some of those people that they think have not been complying if they have received a lot of complaints about the types of materials that have been going out, especially because employees, like I said, can submit training, workshops, programming materials. They can submit videos, sound recordings, you name it, they can send it. And so kind of just be aware that this is open. And so any training that you have going on right now, it probably wouldn't be the worst idea to take a look at that and see if it's potentially violative of this executive order. And again, like I've kind of said before, this is just one other example on the website for the hotline. The specific page, again, references the Equal Employment Opportunity Executive Order, and they're just tying these in so strongly together that if they can't get you on the new executive order, they can try to get you on the other one. So we'll talk about some of the issues that can come up with that might get flagged.
Yeah, so I just want to touch briefly on a number of things we've already talked about. And so we put this slide together to just be kind of a summary for everybody on the types of issues you need to be mindful of. And Krista just talked about the hotline, but certainly the timing of things. I'm seeing, obviously, a number of questions, and we're trying to address as many of those as we go. But let me just add that if we don't get to your question today, please feel free to reach out, email us, and we're happy to talk with you offline about it. But also, I need to let's go ahead and pause. The word, I guess, for CLE credit is stereotyping. That's stereotyping is our CLE word of the day. So please make a note of that. But as you can see, there's a number of issues that I think folks unfortunately need to deal with. The hotline's out there, so you have potential, whistleblowers. You've got the questions about effectiveness of this. I got a contract before. If I was doing something right up to November 21, is it going to impact me? I think at the end of the day, you just need to be prepared for almost anything because there's so much uncertainty. We've got these broad definitions. We've got the flowdown requirements and potentially helping to assist the government and just a bunch of different things. Company statements. I think there was a question about a handbook. I would argue that all of that written stuff could be scooped up into an investigation into this. So I would be very mindful. If you have hired, I know a lot of organizations, because of what's going on in the world, a lot of organizations have hired D&I professionals to help roll out a D&I program, training program. I don't think you put those efforts on hold. I think you just have to be very mindful of these requirements around these efforts and do your best to navigate it. Obviously, I'm a big proponent of D&I. I think it's a great thing, but this is going to make for a difficult environment for D&I professionals to work through. But, I don't think that those efforts should be completely put aside. They just need to be curtailed, as Krista and I have talked about. Just moving on, because I want to make sure we have time for the end. The consequences of noncompliance can be severe, which is why we're kind of pushing on the fact that, you should kind of tone down some of your training, at least for the period of time that this is in effect. And that period of time may be short, it may be long. We'll talk about that in a second. But termination of a contract is certainly on the table. The investigation alone could be costly and bring reputational harm to an organization. And then there is the very specific statements of potential suspension and debarment, which is very concerning. And so, these things need to be given, this executive order needs to be given its proper weight, whether you agree with it or not. It's going to have very significant potential ramifications. We'll have to see how the enforcement actually unfolds with respect to the government. What resources do they put towards it, et cetera. We're going to talk about that in just a second. So let me turn it back to Krista because we're running out of time and there's some what now and what next things that we really want to talk to everybody about. Krista?
So basically, like we said, just, stop all unconscious and implicit bias training specifically. That doesn't mean stop all diversity training, but stop that type of training for now. And some of the significance too of this, request for information and public statements. I'll hit on public statements first and then tie it into the request for information. As some of you might have seen, there's a ton of news articles lately on how Microsoft and Wells Fargo are undergoing massive investigations by the Department of Labor. Basically, their argument is that their commitment to hire certain categories of people, like certain race, by a set goal, 5 years from now, the Department of Labor is saying these resemble illegal quotas and they could potentially discriminate against white applicants. And so it seems like a lot of the focus on this, including some of the language in the Federal Register RFI, is basically there's a concern that white men in particular are being discriminated against because of recent events. And so some of the focus of these investigations is if you have white male employees who feel like they're being targeted or told that, it's their fault, like that other races or genders are not where they should be. That's exactly what the request for information is looking for. If your company is making a public statement on that, I would take a look at those articles on Microsoft and Wells Fargo because they're having the unfortunate experience of facing an investigation now. And so, if they're not capturing you with this training, like through a manual or otherwise, like Diz was saying, they could get you through a public statement. I think it's really important to also take a look at Executive Order 11246, the Equal Employment Opportunity Executive Order we've been mentioning so frequently, especially as you'll see, the RFI that came out today, they're accepting responses, and there's 10 enumerated questions that they have. You're able to take a look at it in the Federal Register. You have until December 1st to respond to the RFI. This will kind of answer some people's questions from earlier too. It actually specifically identifies some examples of what the Department of Labor deems impermissible. It says examples of impermissible scapegoating or stereotyping include training materials stating that concepts like objective, rational, linear thinking, hard work being the key to success, the nuclear family, and belief in a single God are not values that unite Americans of all races, but are instead aspects and assumptions of whiteness. So that is not okay to be going out and scapegoating or stereotyping that. And going back to the broad definitions, I do think by using the word scapegoating, they've been able to capture a large aspect of an entity's ability to have discussions because that word alone kind of permits them to have a broader interpretation. Moreover, this RFI is an interesting aspect of it, hitting right off of what Diz was just saying for the consequences of noncompliance, which you don't want to be suspended or debarred, and you don't want to lose your contract either. And like we said, if you have 1% of 1% of all your business falls under this executive order after November 21st, it does not matter. Your entire company is subject to this now. There is no exemption if you're able to silo parts of your company right now to get another part safe away from it. That's not how this works, unfortunately, unless the Secretary of Labor, Scalia, decides to do that. And so one of the ways in which this executive order is tied for the request for information with the Equal Employment Opportunity Executive Order is that they issued a news release saying that OFCCP will investigate complaints following its normal complaint procedures as detailed in the Federal Contract Compliance Manual. So if you're curious more about how that works, I would definitely take a look at that. The news release got released yesterday on DOL's website, and they're basically trying to invite companies to offer even more here, in that the request for information and the news release basically say, as part of its efforts in support of affirmative action and non-discrimination in employment, OFCCP will also offer compliance assistance to companies who provide materials through the RFI. And those are the 10 questions that I mentioned that are in the RFI. They're essentially asking contractors, subcontractors, grantees, because we still don't know, what's going to happen with grantees. Are they going to have the same clause that's in the executive order? We're not sure yet. We'll probably know in November. But some of those questions that they include that they're asking for is, what type of training is happening? How long was that training happening? How frequently does that happen? How much money do the companies spend on it? Who are the individuals who are developing the materials for it? So HR people should be very aware of that, because the next thing you know, you're going to be getting an email from them saying, hey, we heard that this is happening. We got information from the request for information, which is essentially permitting the government to just have an entire repository of information on contractors, and just run with it. And so something that's also concerning with the RFI is that they keep saying, you know, come and voluntarily offer your materials and let us take a look at them. We'll let you know if they're fine or not. And one of the things that stuck out to both Biz and I is that, you know, while they're seemingly so kindly offering to look at contractors or subcontractors' information today, you could submit the RFI today and ask for it, is that while this doesn't go into effect until the 21st, you're like putting a target on your back now if you submit that, because the RFI specifically says that if you don't fix what we tell you to fix, then you're going to be deemed not in compliance and you're going to have sanctions. So this friendly invitation to submit material is really not that friendly, because if you disagree with their evaluation and assessment, noticeably without any other DOL guidance right now, they have so much free-for-all because, as we know, courts give so much deference to agencies if there's ever disputes on interpretations of things. And so because there's just this utter lack of interpretation from regulations or other guidance, and because the EO was written in such a broad manner, if you voluntarily agree to submit all your stuff, I just don't think that that's a great idea, because the RFI also does not specify how many days you even have to fix the problems that they tell you to fix. I mean, what if there are, you know, what if it's an enormous amount of work that you have to do to change everything? The RFI doesn't say how long you have to fix everything. It also doesn't specify, well, what happens before November 21st? Presumably nothing, because it's not in effect. But that doesn't mean they can't get you under the Executive Order 11246, the Equal Employment Opportunity Executive Order, because that's what they're doing already right now. And so that's why we've been talking about this relationship between the two so much, because the government's trying to get as much information as possible. And even though this goes into effect after the election, if Trump wins again, this is not going away. And so that's like an interesting aspect of it. Just be so aware that they could pretty much have a hot list that they're going to hit the button on the second that November 21st date starts. And even though this is under the guise of, we're here to help you, we'll answer your questions, if you don't agree with them and there's no other guidance that you can point to as a defense, you're kind of out of luck. And so I think it would be a good idea, especially for your HR people, to take a look at what this request for information says. Again, that came out today, but I would put a voluntary investigation in quotes, because I just don't think it's a particularly great idea. So we also recommend, for those same reasons, to really take a look at company training programs, manual, and materials, including if your contracts have something in it. I know we've talked to some people that there's a possibility that sometimes when you have a subcontractor, you'll include certain provisions about diversity concepts in it. Take a look at those too, because that all falls under this umbrella. And you don't want to have DOL knocking on your door saying, hey, we think that there's something weird going on here. Let's take a look into this. You need to open up all your stuff. We want to see everything that's been going on. And so that's why we also recommend looking at existing contracts, subcontracts, and grants, particularly if there's a potential for follow-on work. I think it's a fair interpretation. If you have the possibility of exercising an option under a contract, if that's exercised after November 21st, guess what? That could be perceived as a new contract. And so even though you first entered into that contract before the November 21st date, it doesn't matter, because if they're exercising an option, arguably they can say, well, we got you here, so now this whole contract is subject to it. And not only is that whole contract subject to it, everything else that you have with the federal government is subject to it. Your entire company, even your private operations, are subject to the executive order. So really be aware of some of the upcoming dates that you might have for an extension of an option or another purchase order. Really take a look at it. If you know that you're being considered to do subcontract work, I would be super mindful of that. When is that going to happen? Take a look at that. And then most importantly is have a diverse array of people available to answer employee questions and concerns. You don't want to just make this a black box in your company, right? It kind of underscores the goals of the Equal Employment Opportunity Clause and affirmative action programs. It's so important to foster diversity and varying ideas. And that's why this executive order is so difficult for us to comprehend in so many ways, because it is so broad and ambiguous. but make sure you have those people available, because sometimes one of your employees just might not feel comfortable talking to someone. You know, maybe a woman wants to speak to another woman. Maybe a woman doesn't want to speak to another woman. Just make sure that there's someone there that they can talk to that they feel comfortable with, because again, not only does the RFI say, hey, people from the public can call in with information, but your employees can too, and you never know if you accidentally upset someone and the next thing you know, they call the hotline, and guess what? The RFI gives those employees so many protections, so similar to whistleblower protections, that if they're calling that in, that's confidential. And importantly, if you submit information in response to the RFI, that's actually subject to public disclosure. So if you're submitting materials voluntarily in response to this RFI, if someone's submitting a FOIA request, it's quite possible that they're going to get access to all of your materials. And so that's kind of one other thing to consider if you do decide to voluntarily respond to it, or you have employees calling in, to just be aware that anything that's kind of going out there could ultimately become available to public disclosure. So Diz is going to talk
Thanks,
about.
Krista. And I know we're at the hour, so want to let you all go. One quick point on the RFI is, you know, a lot of industry organizations and associations have written to the administration to denounce the executive order. I would implore that if you want to comment on the RFI or provide or comment on the executive order through the RFI process, I agree with Krista. It's crazy to think that you should submit your training materials for review. But I would advocate that industry organizations, associations that represent government contractors and grant recipients may want to provide just comments in response to the RFI. So that's a way to do it, where you have a little bit of separation from your name being put front and center in front of the government. What next? I'll be 30 seconds or less. Chris already mentioned, under Trump administration, a second term, you know, this is most likely going to stay in play for another 4 years. Under a Biden administration, I have to think that, you know, every time there's a change in party, there's executive orders that are rescinded and new executive orders issued. I have to think that this would be near the top of the list of a Biden administration to rescind. But keep in mind, just because the Biden administration wins on November 3rd, if we have certainty, on January, he doesn't take office. He would not take office until January 20. So you have about 3 months of limbo, where Department of Labor could be enforcing things for about 2.5 months or 2 months. We have to see how the election plays out. Obviously, not sure how rigorous DOL will be if Biden wins the election. The other is, what if we're in limbo, right? There's a lot of talk we might not know on November 3rd or November 4th. What if the election goes into litigation and ends up, you know, going to the Supreme Court? That could take another month. That could only create longer uncertainty. So unfortunately, while we raised a lot of questions, we hopefully answered some of your questions. Unfortunately, there are still a lot of questions. We will stay on top of this. We will continue to issue alerts, and we may have even another webinar on this as things evolve. So with that, I want to thank everyone for sticking with us for a couple minutes past the hour. Be well, and we'll hope to talk to you all soon. Thanks so much.